All right, well, let's get started. Thank you to everybody for joining the webinar today. Today's panel is going to be discussing mediation and bankruptcy. If you have any questions during the discussion, you can post them in the Q&A chat box and we'll pick them up there. We'd like to thank our sponsors. There we go, sponsors. We have a lot of great sponsors for TMA that make these events possible, so we appreciate them. There'll be a networking session right after the panel. The link for the networking was in the email and the event link that Amanda sent you, and then she'll also post it at the end. Finally, we have some upcoming events. Check out the website for more details. All right, let's get started here. Stop sharing. All right, so let's get started. My name is Jason Bank, and I lead the bankruptcy restructuring practice at Kerr Russell in Detroit. I'm also a certified mediator and the vice chair of the mediation panel in the Eastern District of Michigan Bankruptcy Court. With us today, we have an excellent panel. We have the Honorable Daniel Opperman. He's a U.S. bankruptcy judge for the Eastern District of Michigan in Fenton Bay City. He's also the chief judge of the bench. He was sworn in on July 13th, 2006, which means 15-year anniversary is coming up here. That's impressive. Prior to taking the bench, he practiced with Braun, Kendrick, and Finkminer, concentrating in litigation, bankruptcy, and real estate. Michael Baum is the managing partner of Schafer and Weiner, where he acts as counsel to debtors, trustees, and unsecured creditors committee. He's also the chair of the mediation panel of the Bankruptcy Court for the Eastern District of Michigan and the chair of the Rules Advisory Committee. And then finally, we have Dawn Copley. Dawn is a senior attorney with Dickinson, Wright, where she practices in bankruptcy, restructuring, and insolvency, and commercial and business litigation. She's represented both plaintiffs and defendants in hundreds of preference cases. And Dawn is also a certified mediator. All right, so let's get started. The panel today is going to discuss the facilitative mediation process. And I think that with the pandemic hopefully winding down, fingers crossed, there's an expectation there's going to be a wave of bankruptcy filings within the court system over the next few months. And I think that with that wave of bankruptcy filings that are going to come, they're going to be coming a lot of disputes. And I think that mediation has the potential to play a significant role in resolving those disputes. So Michael Baum was involved as who is involved currently as the chair of the panel. He was involved in the formation of the mediation panel over 25 years ago. So Michael, could you provide some background on how the panel was formed and discuss the process?
Sure, I'll be happy to. Thank you, Jason. The mediation panel established by our bankruptcy court is, to my knowledge, the only one of its kind in the country. No other bankruptcy court has a panel which operates with the requirements similar to ours. I will explain. But first, let me give you the background as to how the mediation panel came to be formed. In the mid to late 90s, the Eastern District of Michigan Bankruptcy Court, under the leadership of then Chief Judge Stephen Rhodes, established a bankruptcy advisory committee. Its purpose was to discuss and develop ideas cooperatively with the court with an intended goal to promote justice and efficiency. Numerous bar associations were invited to designate representatives to participate in this advisory committee. There are similar types of programs, committees, bench and bar cooperative arrangements throughout the country. Many of you on this Zoom presentation participate in these types of cooperative arrangements. The advisory committee established many different subcommittees to study different ideas and to make recommendations to the full committee. One such ad hoc committee considered alternative dispute resolution. It was known as the ADR subcommittee. And this subcommittee made a recommendation for a local rule to establish a mediation panel. The full advisory committee considered that recommendation, and a local rule was adopted by the court, approved by the United States District Court, and is now known as Bankruptcy Rule 7016-1, which I think we can now show to you. These are highlights of that rule. There are what I would label more common requirements within the rule, but they include that to become a member of the mediation panel, the membership must be approved by the court. But what is unique in our district is the requirement upon each member of the mediation panel to provide pro bono mediation services from time to time. That requirement, and I can't say this with absolute certainty as I have not reviewed the requirements of all panels throughout the country, but to my knowledge, it has not been replicated by any other bankruptcy court sanctioned mediation panel. The pro bono is that each mediator must be willing to mediate cases with only a minimum payment of $200 per party. I would, however, like to recognize and thank the vice chair of the mediation panel, Jason Bank, our moderator today, who spearheaded arrangements with the Michigan State Bar so that any attorney that provides such services at these minimum charges would be able to qualify for pro bono recognition by the State Bar. But if I can, let me elaborate about fees for mediators. Yes, mediators want to get paid, and they should be. It is the experience of the panel, our panel, that when the attorneys for the parties are consulted prior to the mediation by counsel, a fee arrangement can be discussed and settled with counsel, which allows the mediator to be paid a more appropriate rate. The general rule of the mediation panel is to rely and look toward the court to encourage or even order the parties to pay the mediator an appropriate amount. This is especially true when the parties to mediation have counsel that are being paid.
Judge Opperman, Michael discussed the sort of the need for the court to perhaps encourage parties with respect to the fee issue. And of course, bankruptcy is an area where there's dwindling resources, limited resources. What is your reaction to what Michael's statement was on the fees?
Thank you, Jason. And part I agree. The cases that we think about when they have a minimal fee are the ones typically involving adversary proceedings where there's one party, typically the debtor, who has very little money, and probably is also true of the plaintiff. And the issue is, should the debtor receive a discharge of that debt? Those cases, I think, are different than those that probably many of the people who are on this call are involved with, because the other cases, think your preference cases, think your fraudulent conveyances, think reorganization of the Chapter 11 debtor and all the creditors that are there. Michael's right. Everybody around the table was receiving a fee at probably a very handsome hourly rate. And so it's unfair to ask a mediator who has been highly trained and is spending a lot of time getting ready for this mediation to basically do it for the nominal fee of $200 per party. Those cases, from a judge standpoint, are typically easy to see. And we encourage the parties to talk to the mediator, find out what this rate would be, and then split that amongst themselves. But I think it's key. I think it's important because in a Chapter 11 situation, which is, again, the kind of matters that I think we're talking about today, you want to have a very skilled mediator. And those that are skilled, and I don't want to name names, but we have a number of them on the panel in cases that I've presided over, have done an outstanding job, and they should be paid for that. So I echo that sentiment. I do, however, acknowledge that the pro bono part is so very important. And thank you, Jason, for all your work in making sure that the State Bar recognizes that. So I don't want to horn in on Michael's presentation anymore, but thank you for inquiring. Go ahead.
Sure, thanks, Judge. And Michael, can you discuss the mediation process and maybe how it differs from the state court evaluation process that some are familiar with?
Sure. The mediation process is not mandatory as often seen in state court. Instead, it is a facilitative mediation process offered as an alternative to resolve disputes. There are no sanctions or other forms of coercion in the process. And obviously anything said, discussed, or written in connection with the facilitation is not admissible in any court. In these types of mediation, the panel members serve as a neutral third party whose job it is to facilitate a process of reaching a mutually satisfactory agreement. The job of the mediator is not to assess who is right or who is wrong, but rather to use their skills to guide the party and their counsel and their professionals towards a resolution of their respective disputes. In the past year, our panel has not been used as much as in previous years. We are not sure why, but we speculate this is at least partly because in-person mediations were not possible. We do have some experience with Zoom mediations. A number of mediators on the panel have reported positive results and have achieved many successes using Zoom or a similar type platform. However, there are challenges to the Zoom mediation, and Jason, as you know, we'll discuss them later during this presentation.
Thank you, Michael. So the mediation process in the Eastern District of Michigan, the parties can agree on a mediator, they can agree to go to mediation. The judge then can order mediation, but ultimately, if the parties go to mediation and they want to walk away and they throw up their hands, that they can do that without a penalty. And then it's sort of the mediator's job to cajole those parties to sort of stay engaged and try to work toward a settlement.
That's correct, Jason. When the parties agree to go to a mediation, the parties are encouraged to look at the list maintained by the court of the mediation panel and each of the mediators. They select a person from that panel. They inform the court of their selection, and the court then enters a form order that has been prepared that is sent directly to the mediator as well as to the parties. The mediator is then added as a party for ECF purposes. He gets a copy of that order and it is also sent to him. And at the completion of mediation, there is a form that the court has prepared that the mediator completes. And that form simply says the parties appeared at a mediation and they did settle, they signed a term sheet, they did not sign a term sheet. It is a form, one checks the box, and that gets filed with the court, and it achieves two purposes. One, it alerts the court as to whether or not the adversary proceeding or whatever proceeding that is being mediated has come to a conclusion or not. And second, it allows the court to maintain statistics about the success and failures, hopefully very little, of the mediation process.
Thank you. And on the screen, we're sharing a screen that includes the court rule for mediation. And what we can do is have Amanda share that with the participants. I know a lot of the attorneys, of course, are familiar with this, but some of the other folks that are not attorneys would probably be interested in seeing that. So, okay, thank you. Moving on to Judge Opperman, and I know you've talked a little bit already about some of the fee issues, but could you comment on the bench's perspective on the importance of mediation, and perhaps also discuss how often the process is used?
Certainly, and thank you everyone for taking time to be part of this presentation. I want to back up just for a minute. A few years ago, Chief Justice Roberts noted in his annual report to the court of the expense that was incurred at the federal level in litigation, and there was a problem, and he's right. In this ADR process that Michael mentioned, one of our solutions is the mediation. And if you look at the very first rule in the Bankruptcy Rules of Procedure, 101, it basically says that we are to administer these rules for the efficient and inexpensive administration of justice. That's what mediation in part does. In our Eastern District of Michigan, mediation is very, very important. We have just a highly skilled panel of mediators, very talented. They've been trained to be a mediator. They have a lot of experience in mediation, and we rely on them a lot. Typically, in a traditional standpoint, you'll see mediations in an adversary proceeding, which is a situation where there's typically your classic plaintiff and a defendant or defendants, and they're either seeking a determination whether a debt should be discharged, whether the debtor should receive a discharge, or typically for the return of money, think preferences, fraudulent conveyances, accounts stated, such as that. The mediation moves these cases along faster, and they move it without clogging the court's docket. And while these days the court's docket isn't as clogged as it used to be, it's still a very important tool for people to use. Statistically, and Michael's right, 2020 wasn't one of our better years in terms of successful mediations. But if you go back to 2019, pre-pandemic, on the adversary proceeding area, we had approximately 33 mediations held and 22 resolved in settlement, which is a very good rate of 66%. I'm going to continue this statistic along through 2020 and 2021. In 2020, it was 34, but only 20 settled, which was a 58% mark. But just as importantly, 8 of those cases afterwards settled that don't count as being a settled case, which tells me that the mediation undoubtedly was a springboard to settling the case. So far this year, obviously not so many cases. We've had 9 held so far. We've had 9 ordered, 7 have been held, and 6 have resolved in settlement, which is an astounding 85%. It's kind of too early to tell whether that's going to hold or not, but that was kind of classically our numbers in years before. But for today's purposes, I asked the clerk to give me some numbers about non-adversary proceedings. And that's essentially cases where there's a reorganization going on, the bread and butter of the group that we're talking to today. In 2019, we had 7 cases that were ordered into mediation. And of those, 5 settled per mediation. Another one settled shortly thereafter, which is a very, very high percentage in the 80% mark. Last year, we had 8 that were ordered into mediation. Keep in mind, these are just reorganization cases, and 6 of these settled, which is 75%. This year, we only had 2, and 1 is settled so far. So what's the importance of it? It brings cases to a conclusion faster, more efficiently, and allows the courts and other attorneys to focus on those issues that do need to be focused on in a court setting. It's important to have great mediators like we have because they can cut to the chase right away. They know the psychological drawbacks to settle, and they can get over those drawbacks, I think. So we rely on them a lot. And we're so thankful for the efforts of our mediators and frankly, the efforts of our attorneys who do the mediations, representing parties and the parties themselves, because it's designed to basically facilitate and move these cases along much faster. And we'll get along to a case example in a few minutes here, but you'd be surprised the number of cases that are successfully mediated when people really put their mind to it. So Jason, I hope that answers your questions and concerns. And I think we have some pretty interesting case studies that we want to talk about in a few minutes.
Yeah, we do. And I think the stats show me at least that you're probably not going to lose your day job anytime soon. But the hope is that more cases will go to mediation and make your life a little easier, right?
Right. Well, you know, it's always nice to have your life a little bit easier. Yeah, I don't worry about my day job too much because there's always something that comes up. But I'd be delighted if the adversary proceedings settled much faster, because I think that's a good thing for everybody. And as I've joked a number of times, do you really want someone like me deciding your case when you can come together by an agreement with some highly skilled attorneys and mediators to come up with the solutions that's much better than I can come up with? Because frankly, I have blunt instruments. I enter a judgment in a certain amount, or I deny a judgment. Mediation explores a lot more avenues for a great settlement for everybody. So don't make me use the blunt instrument, but I will if I have to.
Yeah. I think, Judge, you make a good point on the fact that even the cases that do not settle, and I know that some of the cases that I've mediated, I've heard from the parties afterwards that indicated that they did settle and that the mediation was often the first time where they got everybody in the room and they were able to narrow issues or at least hear what the other party had to say. And that, as you said, it was kind of a springboard for a settlement.
Right, and regrettably, we really can't track those through our certificate process, but we have kind of informally tracked them over the years. It's stunning the number of cases that go to mediation. Certificate says they did settle or didn't settle, did or didn't settle. But if they don't settle, lo and behold, about a month later, they come up with a stipulated order. The mediation must have helped.
Yeah, very good. Thank you, Judge. So Dawn, you have represented hundreds of plaintiffs and defendants. You've taken a lot of cases to mediations. I'm sure you had some successes in them and some failures, but hopefully more successes. And you've been doing a lot of these in adversary proceedings, which for those that don't know are sort of traditional plaintiff defendant lawsuits filed within the bankruptcy court. So Dawn, can you discuss the mediation process in those adversary proceedings and the roles that attorneys, financial advisors, and accountants play?
Thanks, Jason. So, when we were thinking about focusing on an adversary type of adversary proceeding, as Judge Opperman was saying, there are legal basis for a lot of different kinds of causes of actions in adversary proceedings. We're talking about avoidance actions and particularly preferential transfer actions that are adversary proceedings, both in Chapter 7 and Chapter 11 cases. There is typically just a plaintiff and a defendant. It's not the multi-party cases that Michael was mentioning earlier when you're talking about trying to resolve a dispute in the main bankruptcy case. This is the adversary proceeding filed under the bankruptcy case. And it's usually brought by the representative of the bankruptcy estate, whether that's the debtor or the Chapter 7 trustee or some other entity that has authority to bring them. It's when you're talking about litigating preferential transfers, and I have done hundreds of them. I've been both plaintiff and defendant, counsel for plaintiff and defendant. And of those hundreds, and we've gone to mediation probably, I haven't actually counted, but I would estimate I've done about 100 mediations for preferential transfers. And I will tell you, hundreds of cases, we've not gone to trial on any case. Preferential transfer cases typically settle either by the parties just talking to each other or through mediation. Mediation is a very effective tool in this type of adversary proceeding because the facts that you're working with are derived from the account information, either from the debtor or the creditor. So it's a very cut and dry, if you will, kind of information that you're sharing with one another. And it's easily looked at by each party. In a moment, I'll show you kind of how you might be able to illustrate that. And so what typically happens in this type of adversary proceeding is that the parties can come to a resolution or are able to see, okay, here's what the defenses are going to be, and discuss those, talk about where they agree and where they don't agree, really more readily than in the type of case that you might have, like a breach of contract case or some other sort of cause of action, where your information, your facts that you're working with are derived more from witness testimony or some other type of documentation that's not as concrete as the stuff you're working with typically in this type of adversary proceeding. So they lend themselves very well to mediation.
Yeah, and preference cases too are one where there's some certain cut and dry defenses, right? But a lot of the defenses, whether it's ordinary course of business, it's really not cut and dry. And so what is the role that, do you see financial advisors going to mediation with you, or is it more in the preparation stage?
Okay, well, yeah. So, there are, of course, nuances. I'm not trying to say that, you can get rid of attorneys that need to, actually make argument here. But you are still working with financial information, even when you're talking about something that has a little bit more of a subjective perspective. like ordinary course of business has. But in every litigation, and especially preparing for mediation, I think preparation is key. The more you're prepared, and when we were earlier, when people were mentioning like there being settlement after mediation, because that might be, mediation might be the first time that the parties have been in the room together. I think, having been a mediator and having participated in mediations as a party, the parties need to prepare for mediation before they get into the room. You need to have looked at what your defenses might be if you're the defendant, and done some research, maybe legal research, to support your position beforehand. You know, there are too many times when parties get in the room and say, well, you know, we have a vague notion, they might not use that word, but a vague notion of this might have happened, or we think such and such happened, without having done any investigation of that. And oftentimes plaintiffs don't look beyond, they filed a complaint and they haven't, even if the defendant has in their answer or in some discussion with them raised some defense, the plaintiff has ignored it and it's going to stick to their guns. You need to do some preparation, because you are wasting the mediator's time and your own time coming to a mediation that you're not prepared for. And if someone is raising an issue, even in mediation for the first time, you need to consider what they're saying, even if you're going to end up dismissing it or think that it's, you know, they're kind of full of it and they're just throwing up stuff to, you know, make a commotion. You need to have at least considered it. And that's what mediation is about. If you come in there with a closed mind, then you might as well just proceed to summary disposition, or, you know, something like that, summary judgment, a dispositive motion, rather than coming to mediation. There's no point in it then.
Absolutely. And then I think you were going to go over a slide. Let me see if I can pull that up.
Yeah.
See if I can do that. And an example, I think, of sort of some of the homework that's so important pre-mediation. And some people make the mistake of sort of going to the mediation and expect the mediator to kind of wave a magic wand and kind of see their point of view. And that just doesn't happen. So can you see that? Is that up?
I can see it.
Okay.
So, yeah, if I could, because part of the question you asked me that I don't think I fully answered was, I know participating in today might be different types of professionals, attorneys, as well as financial consultants and other types of professionals. So one of the questions, Jason, you asked me that I don't think I fully answered was, what type of role might those professionals play in a mediation? And I've never been in a mediation where a financial consultant was actually in the mediation, at least not in preference litigation. But that doesn't mean there's not a role to play, particularly in helping your client with preparation. And so for plaintiff, so what we have up on the screen is an example I put together, and believe me, this is completely made up. This is not something I've ever used in the case. I completely made it up. And it's something that I like to do. And I usually do this analysis myself. I don't use a financial advisor when I'm representing a defendant. Although when I represented a plaintiff and we had a couple hundred cases, we did use the financial advisor to do this for each of those cases. And what this is showing, and the reason that I bring this to everybody's attention is, the more information in a form that illustrates what you're talking about, what you're presenting, the position you're taking, the more you can present that in a simple form and something that the parties then can use to as a jumping off point to discuss where they agree and where they don't agree. And it helps the mediator, it helps all the parties present. It's something like this. And for preferential transfer cases, they lend themselves to this type of visual aid, maybe more than any other type of case. they definitely do. And so this is something that I do in every case, like I said, when I represent a defendant, and even in plaintiff cases, financial advisors did it. Folks out there, you might do something similar. Maybe you have some proprietary software that you use to generate something that's similar to this, maybe not exactly like this, but it's something that a lot of attorneys use when they're talking about preference cases and having discussions with the opposing party. And so what it basically shows is the columns to the left, the first 3 columns to the left show the information about the preferential transfers that the plaintiff is trying to recover. And then the next couple columns show the invoices that were paid by those transfers. And then the next columns assert what ordinary course of business defense that's being asserted by the defendant. And then finally, new value defense being asserted by the defendant. And this is by no means all the statutory defenses that might be available to a defendant. It's just kind of the ones that are most often asserted by defendants. And then the final column then shows what the net exposure for the defendant might be. So for plaintiffs, they often will have their financial advisor. Plaintiffs are usually like the debtor in possession or a trustee or what have you, will have their financial advisor put something like this together for every plaintiff. And they actually use it for a couple different reasons. Sometimes they have these things done earlier in the case when they're trying to formulate their Chapter 11 plan, because it helps them understand what kind of defenses might be brought and how much ultimately the resulting settlements with these defendants or judgment against these defendants in the aggregate might be, so that they know what funds they might be able to recover for the estate, and that might be able to be available for distribution to the creditors. They also do it so that they have an idea of what parameters to set for, in mediation, if they're trying to have resolution of the case, or even just in settlement discussions with the defendant party. So it's something plaintiffs do for every case, just about. I mean, there are some smaller cases where, they won't have hired anybody to do this and they'll just sue. And it's something defendants should do. Now, plaintiffs might not share this, even in mediation, with the defendant and the mediator, because they don't want to show their hand of what they think the defendant's defenses are. But it's certainly something defendants, I think, should share, because it clearly sets out your position on your defenses. And then the parties can, talk about, well, I don't agree here, I agree with you here. It goes a long way in working toward resolution.
Okay. Thanks, Don. And just as a comment, and Michael's going to talk in a minute about mediation by Zoom, which is sort of a whole different topic, but one of, I think, the benefits of Zoom, and I did a mediation earlier in the year where a financial advisor actually did participate in the mediation by Zoom, and I think that's one of the benefits of Zoom, is that it does allow a financial advisor to sort of just pop into the mediation for an hour and talk to the mediator, and then he can kind of pop back out, and which is much better than going down and sitting in an office for 8 hours and sort of waiting to be called. So thank you for that. So we talked a little bit about the adversary proceeding, and of course, there's a lot of disputes in Chapter 11 cases, business cases where we have the melting ice cube, the business is failing, lack of resources, and things like that. So Judge Opperman, can you comment on your thoughts on the usefulness of mediation and Chapter 11 cases, and in particular in the recently enacted Small Business Reorganization Act?
Certainly, be glad to. And first off, a little mea culpa by me. For many years when I practiced, I didn't think mediation in Chapter 11 was a worthwhile thing. And that even spilled over once I became a judge. But shortly afterwards, I had a Flint case, and Dennis Haley, very good attorney in Flint, suggested mediation. I thought to myself, you're nuts, because you're never going to get these group of diverse people together in one room or in one building to agree on anything other than there's the exit door. But I was at least smart enough to think he's onto something here. So I said, if you can agree on a mediator, have at it, because I thought it's not going to hurt me any. And it worked. It worked magnificently. He basically put everything together with the help of a mediator, and they got a confirmable plan within a month's time. So I'm not going to take just one example and say, does it always work? Because it maybe doesn't. But it made me think more often we need to think about mediation in Chapter 11s, because it's an opportunity for one person, the mediator, to bring in diverse groups of people. And usually that's the debtor's attorney's job. But the debtor attorney sometimes is overwhelmed by the number of constituencies. If you bring them all together in one room, I think it works. And I've had some cases recently where I kind of had like a mediator on standby, because every case, this case had an issue that would come up. I kind of felt bad for debtor's attorney, because it seemed like he'd get one little thing solved and another thing would pop up. So I think it's a very useful tool, and we can go around on when do you do it and when shouldn't you do a mediation, but think about it more often. And I want to pick up on something that Dawn said. I think it's useful to have a financial person there in mediation, because quite often at the end of the day, the question is, what can the debtor afford? And debtor's financial advisor probably knows that better than anybody else. And I know there's I think I can get a little bit more out of the stone. But if you got a financial consultant and advisor say, no, this is all that can be cash flowed, it goes a long ways. And if you represent a creditor, you better have your people on there too, because maybe they're blowing smoke your way. But it's a way to air it out and get to yes a lot faster, I think. So Jason?
Thank you. Have you seen, I know the subchapter 5 hasn't been around for too long, but have you seen subchapter 5 trustees sort of playing kind of a mediator role?
I have, and thank you for picking up on that, because you asked the question and I only answered part of it. So I should take my own advice a little bit better and listen to the question, answer that question, don't come up with something else. But absolutely. A couple of years ago now, Congress passed the statute, made it effective in 2020. And there's a subchapter 5, chapter 11 trustee, which is a mouthful. So I usually just call him the trustee in the chapter 11. And one of the duties of that trustee is to mediate, because the trustee is in a unique position to basically be able to gather information from the debtor, the creditors, and then mix it all together. And I've had one case, it's actually two cases together, but they were related, where we successfully had the trustee mediate, and it was, since the case is now essentially complete, I could talk about it a little more, but it was the infamous Boys Hydro cases where the dams in the Sanford, Michigan failed and caused millions of dollars of damage. The debtors were able to reorganize, as that word is used broadly. Case was filed in late July, early August, and plan was confirmed in February. Wouldn't have happened without a mediator. Got another case right now where the mediator, I think, is going to do a fantastic job. But that's part of their job as a Chapter 11 trustees, is to mediate. And I think it's working famously so far.
Thanks, Judge. Michael, so you've represented a number of debtors in Chapter 11 cases. You've also acted as a mediator in a number of Chapter 11 cases. And you were recently involved in some complex litigation with many parties, and you did it all over Zoom. So could you share that experience in how you deal with mediating multi-party disputes, and also maybe discuss the drawbacks and benefits of doing a mediation over Zoom?
Thank you, Jason. The case that you're referring to did involve multiple parties. It was litigation arising in connection with a Chapter 11 plan, where 14 defendants were being sued by I don't want to call them received, by a plan administrator on behalf of unsecured creditors. There were 5 separate insurance companies involved, and each one of those And each one of those insurance companies had their own claims adjuster. Let me tell you that this was during COVID at the height. And so there was no choice then to even consider the possibility of in-person mediation. And so we had to do it over Zoom, and we had people in multiple states, as well as around the state of Michigan, a lot of people up north and on the west side of the state. And I don't know, Jason, I know you know, but many of the people who are watching this may know about me, but I have a Bachelor of Science in Computer Science, and I say that it is with distinction. However, my Bachelor of Science was, I got it on a computer, which was a model, an IBM Model 370. It was Model J65. It occupied about twice as much space as our suite here, and we have about 10,000 square feet. So it was about 20,000 square feet, the size of this computer. And I only once dropped a pile of punch cards when I had to deliver my program. And for those of you who remember what it's like when you drop your punch cards, it is a disaster. However, since that time, this telephone does about 100 times more than anything that I was ever able to do on that computer. I was very fearful of running a Zoom by myself. And I'll give credit to Howard Shear, who suggested, who's on the panel, a very good mediator, who suggested to me that I get somebody from a court reporting service who had mastered and was mastering the tools of Zoom. And what happens is that you create breakout rooms. You create different rooms for the different parties to go into, much more or less the same way we are right now in one room where we see only the four of us, and we don't see anybody else who is here, who is watching us. So we don't see them. They see us, I imagine, but we're not able to see them. That maybe that's a question of just turning off the video, the mic, however that works. It doesn't really matter. But what's important to the mediator is that mediation is a process whereby the mediator goes from one room to the next room. He goes from one party to the next party. It is important during that, what I will call downtime for the party that is not being visited by the mediator, that client, counsel, a financial advisor, if one is there, meet together to consider the various options and discussions that might be going on in the other room. That downtime is vital to the process of mediation, because a good professional, a good financial advisor who is knowledgeable about a case has the opportunity during a very a concentrated amount of time, because the mediation is hopefully only one day. So during that period of time when the mediator is not in the room, a financial advisor and counsel who are prepared with all information are able to educate their client what the risk is, what they're facing, what might possibly happen, what could happen if we, as Judge Opperman said earlier, we ask for a blunt decision, how that might turn out. Is it a flip of the coin, or is it weighted in one direction? What might be the ramifications of each one of the various possibilities that are happening? That downtime is very important. And in Zoom, you can't control that all of the people will stay in one breakout room, because people tend, if they're at home, if they're in a remote office, if they're in a remote location, what happens is three people are assigned to one room, but you have no way of knowing whether or not the three of them are actually meeting together and using that time productively and constructively towards making the mediation more meaningful and giving it more of an opportunity to work. And so that is a downside. But with professionals, financial advisors who are ready and willing and want to participate in the process, one would think that they would make use of that time. There's also a very subtle difference between Zoom and meeting in person. And I'll give you an example. Right now, when I'm looking at the screen, I am looking directly, Jason, at you. But the reality is that the camera is up there. So if I wanted to really talk to you as a person does one-on-one and trying to be persuasive, I would have to pick myself up to look at the camera of my computer here. But what happens is I'm no longer looking at you. And it's disconcerting to me because as I try to persuade you about a particular point, I'm not seeing you, I'm looking at the camera. And if I look down to look at you, then I'm not really looking at you because the camera is looking one way and I'm looking the other way. And so it's a new way of speaking to a person one-on-one. And it's as difficult as it is to appear in court on a conference call when you don't have the opportunity to see the person and really get a feeling for where they are, because part of hearing speech is seeing speech. And it is it is one of the ways we try to gauge what somebody's saying and try to read them and understand them. It's just the way we are as humans. But you miss that opportunity of being able to be engaging one-on-one. Zoom makes that, I shouldn't say impossible, but it makes it challenging. And you have to just appreciate it and work with that. All in all, in terms of Zoom, yes, it works. It works if you have professionals involved on both sides and you have a willingness to want to make it work. It has challenges, but well-trained people with the good intentions of trying to achieve the resolution can overcome those challenges. If you're prepared, you're educated, and you are willing to make the process try to work.
Yeah, it's interesting too, because when you have litigants flying in from New York or what have you, then there's almost this notion of this sort of pressure to settle. You don't have that pressure to settle over Zoom necessarily, and that's why establishing that sort of that personal relationship and doing that one-on-one is so critical. Do you, Michael, tell people they cannot leave the breakout room unless you give them permission, or do you let them kind of come in and out?
Well, as a mediator, I wish I had the power of Judge Opperman to order people to do things. But suffice it to say that as mediator, I try to speak with the professionals ahead of time, and I try to encourage them to block the time, not to get involved in other kinds of items, and to use the time productively, so that they are able to be there to answer all of the doubts of their particular client. I encourage them to be in the breakout room as much as I possibly can.
Great, thank you. So we have about 10 minutes left before we go into the networking room, I think. So just a reminder, if anybody has any questions for any of us, feel free to add that to the chat room. And I think that maybe for these last few minutes, maybe we can kind of go around the room and talk about maybe helpful tips or tidbits for doing a successful mediation as a litigant. And so the one thing I want to just mention and tell a little story on is I think it's very critical to have a discussion with your client before the mediation, and not just sort of 5 minutes before, but actually days before the mediation, to explain to them what mediation is all about and kind of get them in the right mindset. And then as an attorney, it's important to remember that you are in mediation and you're not necessarily in court. And there's always a natural tendency where you want to sort of, you need to kind of puff out your chest for your client, but that doesn't do you so well in mediation. And I had a case one time that I mediated, and it was a non-dischargeability case, and it was a plaintiff with the state court attorney. So it wasn't somebody that you see in bankruptcy court, so no one can try to guess who it was. And it was a very contentious case involving a former couple. And I kind of made the comment beforehand, like, okay, well, we're going to give an opening statement and make sure that we keep it constructive, and we're here to try to settle. And the plaintiff's attorney basically said in the opening statement that the defendant, and looked at her in the eye on the Zoom video and said that the defendant should be in jail. And so needless to say, that did not settle. And I think that the defendant, when they heard that, was just basically turned them off, and it was their unsuccessful mediation. And I compare that to a mediation that I did one time where actually Michael was the mediator, and I was representing a creditor in a Chapter 11. And it was one of these creditors where when you talk to your to your client on the phone would be hot because you could feel the fire coming through the mouthpiece, or through the earpiece rather. Very, very upset. And so we went to mediation on a Chapter 11 confirmation issue. And it's one of these mediations where, I kissed my kids goodbye in the morning and I said, yeah, I'm not going to be back until probably midnight. This thing is just never going to settle. And we went to the opening session, and the debtor, first thing the debtor says, and looks in the eye of my client and says, I'm just sorry it came to this, and I want to see if we can work this out, but I'm truly sorry. And needless to say, that really took the heat and the frustration out of my client, and the case ended up settling by like 2 o'clock that day. So I think that it's always key to talk to your client, and if you are the client, to sort of be in the mode of, we're here to settle and we're here to kind of be constructive. So let me maybe go around the room and just start with Dawn. And then Dawn, I don't know if you have any tips, maybe in a couple minutes you can give maybe a tip or a helpful tidbit.
Yeah, when I was hearing you speak, Jason, it put me in mind. I often say to people that we're attorneys and counselors. You know what I'm saying? And so sometimes our clients want to hear only, we're going to go in there and we're going to fight and we're going to win. You have to, particularly when there's, you're going to mediation, you have to explain to your clients, this is an opportunity for us to talk. And if we don't like it, we can walk away if it doesn't resolve our issues here. But we need to listen, and we need to consider, I said that before, what they're saying. You don't always have to agree, but I agree with you wholeheartedly that you have to have some discussion with your client before you go into mediation. Not only explaining to them how it's going to go, because a lot of even, sophisticated corporations, the representative that's going with you to mediation may never have been in a mediation. They don't know what this is going to be like. You have to explain what the process is. And so that they're comfortable with, we're actually going to talk and we're going to be civil to each other. We're going to hear them out. And yes, we'll have an opportunity to tell them why we think they're wrong. But we also need to consider that, between us, maybe they're right, and have a real discussion about what happens to us if they are right. And do we need to resolve this right now because they could be right? And do we even have some indication that what they're saying, they might prevail at the end of the day? You have to be prepared with those kind of things. It's not appearing before the judge and making your argument and being, adamant about it. It's a discussion. And I think the most successful mediations are when the mediator, as Michael was saying, maybe in separate rooms, you have breakout rooms where the mediator comes in and is honest with you about what they see, the holes in your case being, and even what they see the holes in the opposing party's case being, from the, a completely unbiased perspective. Here's what I'm seeing. You might not be seeing that because you're too far in it. Here's what I see. Here's what I think a judge would see. Now you take that for what it's worth. And I think that that's what a successful mediator does.
Good comments. Absolutely. Michael, do you have any final thoughts? Maybe in 2 minutes or less?
Yeah. My final thought would be, when I first took training in mediation, I was there with the likes of Wally Handler, Ron Rose, and a number of other, as I'll call, senior elderly statesmen. And I remember them beginning the process saying, I have to go to a mediation training to be told how to settle a case. I can settle a case better than anybody. I remember them saying that. And at the end of the training, they all, myself included, said to a T, oh my gosh, there really is a skill to mediation. There is a process. And Dawn is right. If counsel should realize, whether you've had experience and the financial advisors watching this as well, whether you've had experience involved in a mediation or not, I can assure you, mediation is a process that works. And while your client may not be thrilled with the outcome, he will be thrilled that the litigation is over. you will be doing a great service to your client, encouraging mediation. I mean, we've got a great panel. You can pick anybody off the panel, and your clients will be happy because they will save fees and they will consider you to be a great professional if you give that process an opportunity to work, because I assure you it will work with a good mediator.
Thanks, Michael. Well said. Judge, we'll give you the final word.
Well, thank you. I want to echo what both Dawn and Michael said, and that is, and also expand on something I said earlier. As a judge, I only have certain things I can do, and they are truly blunt objects. I can enter a judgment. But the beauty of mediation is that you can sit down with a mediator and say, listen, to pick up on Dawn's point, maybe we didn't realize we had a weak case until we sat down. Now we realize that we do have a weak case, so we need to settle, but we want to settle under terms that we can afford. I can only enter a judgment, but good mediators come up with solutions that are win-wins. And keep that in mind, because I've seen a lot of mediations that come together. I couldn't have entered those kind of sanctions or those kind of awards because it's not within my ability. But you can agree to a lot of things in bankruptcy. So consider it strongly.
Thanks, Judge. And just want to thank the panel for all of their outstanding work in putting this panel together today. Hopefully it was informative. And with that, Amanda, I guess I'll turn it over to you, and you can tell us, I guess, the next steps on going into the breakout room, or the other Zoom session, I guess I should say.
Yep. Thank you all so much for helping out with this panel and speaking to us today. Thank you, everyone who attended. We are going to go into networking now. So I just posted the link in the chat. So if you just click right on there, it'll take you right to the next room, and I will open it shortly. And make sure to check out the TMA website, turnaround.org/Detroit, for all of our upcoming events. We're trying to plan a lot of cool stuff, including our golf outing in a few weeks. So I will see everyone in the networking room. Thank you.